Right. Very good afternoon, colleagues joining us from across the region. I hope you're all having yourselves a very lovely Tuesday afternoon. And it's the month of June, a month that is dedicated to men's mental health. So shout out to all the men out there. And if you have a man near you, say hello to them and hope that they are doing well. And I mean by well, I hope they are actually doing well. The British taught us a very bad habit of when they say, "How are you?" automatically the answer is fine. So this year, this particular month is dedicated to that. But on this month's lineup is an interesting conversation that, captivates many minds, and particularly those who are in insolvency practice, and also those who are business owners. We all know for a fact that there is that one headline that we all don't want to hear or to read about in the news. And that headline of recent has become very, very popular, of X and Y company collapses or assets missing, or courts in over 3 jurisdictions are hearing matters pertaining a collapse of a company, or directors are facing personal liability. Those are discussions that no business owner wants to hear at the end of the day. And today we have a very interesting discussion that revolves around cross-border insolvency. Now, as we all know, East Africa is integrating and assets are spread across partner states, and there are, lots of issues that surround insolvency. This afternoon, we have a very seasoned panel of 5 practitioners that are joining us today, and each one of them has played a very distinctive role in advising directors, creditors, and courts on how to handle insolvency. But most importantly, before we even go into the discussion, is to introduce the lady that is going to steer our discussion this afternoon, and that is none other than Miss Fatma Haruna Songoro. And Fatma is an advocate of the Court of Judicature in the United Republic of Tanzania. She is a distinguished multidisciplinary practitioner who has a vast range of experience spanning from across insolvency and corporate restructuring, investment and international trade, technology and cyber law, corporate law, regulatory compliance, and dispute resolution. Talk about a lady who wears many hats, and I'll tell you about Fatma Songoro. Now, she currently serves as head of technology and fintech at Victory Attorneys and Consultants, one of Tanzania's leading law firms. She's also currently a fellow at INSOL Future Leaders Program 2026 under the International Association of Restructuring and Insolvency and Bankruptcy Professionals. She holds key leadership positions across professional bodies. She's currently the vice chairperson of the Insolvency Committee of the East Africa Law Society, the vice chairperson of the Tanzania International Arbitration Center, and most recently, she's a board member of the Tanzania Women Lawyers Association and the Tanzania Privacy Professionals Association. In addition, she serves on the Tanzania National Representative for the Young Lawyers Committee of the International Bar Association. And Fatma, just to congratulate you upon your reappointment as a board member of the Tanzania Women Lawyers Association. Because I know that's the most recent. And so hongera sana, we are celebrating with you. And I'd like to hand it over now to you to take us through a discussion on insolvency. And you have us till 4 p.m. So over to you, Fatma.
Thank you so much, Gabriel, for that introduction. Good afternoon to our distinguished panelists and participants. I'm quite proud and happy to welcome you today to our discussion with regard to cross-border insolvency, asset recovery, and corporate restructuring. And as Gabriel has already done the opening remarks, I think we can all agree that the East African region is seeing a growth in how countries are doing businesses. So we see a lot of companies operating across different jurisdictions. We see ownership structures that are spanning over different countries. We see our regional trade and flow getting more integrated within our countries. But much as we're saying that the businesses are becoming regional, the insolvency framework within the region is not structured, and so it's still fragmented. And this results into multiple challenge because every jurisdiction has a way in which they define insolvency, the procedures, how the court handles the timeline, the ranking of the creditors. And so normally when a company goes into financial distress or when they're going through insolvency, there are a couple of challenges that would normally come across. And so we're here today, and the purpose of this session is to confront these challenges of cross-border insolvency and to hear from the experts in this area on the difficult questions that normally arise. What happens when a company collapses within the East African region? What are the challenges that normally arise, and how can you navigate them as a lawyer or as an insolvency practitioner? And so without further ado, I'll be happy to have our panelists introduce themselves very briefly within 1 to 2 minutes. And I'd like to welcome Wamuye to begin her brief introduction. She'll be followed by Susan, and then Isaac, and then Anthony, and lastly, Noella. So Wamuye, please take it over.
Thank you, Fatma. My name is Wamuye Madenge. I am an advocate of the High Court of Kenya. I currently practice in the banking and finance space as an in-house lawyer. However, over the years, I've had the opportunity to represent various clients. Sorry, now you know where I come from. If you're Kenyan, you know exactly where I come from. Yes, I've had the opportunity to represent a number of clients in insolvency proceedings, as well as offer advisory services to insolvency practitioners. I do sit in the ELS in-house, as well as the insolvency committee. I'm also a member of Insol International, and I was privileged to have been selected as an Insol future leader in Kenya in the year of 2024. Thank you.
Good afternoon, fellow panelists. Thank you very much, Advocate Fatma Songoro. Good afternoon, listeners. My name is Nelima Susan, and I'm the managing partner at Hilton Law Group, a law firm that practices corporate and commercial, but I specifically major in banking and finance, mergers and acquisition. I've also been involved in cross-border investments. I also deal with regulatory and compliance. I'm also an arbitrator and a certified international trainer. Thank you. I'm happy to be here, and I also look forward to learn as much as I'm presenting. Thank you.
Isaac, you can go ahead. Isaac, you're speaking on mute if you're speaking.
Thank you, Councillor Fatima. My name is Isaac Nzumuremyi, and I'm a legal practitioner from Kigali, Rwanda. I'm the founder and the managing partner at the firm Lex Chambers. We practice in 3 broad areas of law. That is arbitration, insolvency, and corporate. We only advise, and we can only represent a client in arbitration matters. We don't do litigation. So I'm much more involved in the insolvency practice in Rwanda, although the market is still very small. But I'm honored to be among the insolvency practitioners that are given opportunity to handle these complex matters. I think that is broadly what I can say about myself. Back to you.
Good afternoon, everyone. My name is Noella Lubano. I am a partner at Oraro & Company Advocates. I'd like to say, first of all, thank you for inviting us for this discussion. In terms of my areas of expertise and practice, I do mainly banking and finance work. And in relation to that, I do recoveries, asset tracing, and insolvencies. And then the other side of what I do is international as well as domestic arbitration. And I majorly focus on construction disputes, infrastructure disputes, tech disputes as well. So I think that covers. I'm a partner in the department, in the disputes department. Yeah.
Thank you, Fatma. Hi, everyone. Good afternoon. My name is Anthony Miano. I am an advocate of the High Court of Kenya. I practice in CM Advocates LLP. My specialty is in the litigation field, and one of the areas I do specialize in is insolvency. I am a member of the Association of Turnaround Insolvency Kenya. I'm also a member of Insol International. I am participating currently this year in the Future Leaders Program, as well as being a member of the Insolvency Committee of the East African Law Society. So it's a pleasure to share the stage with my fellow panelists, as well as engage with fellow practitioners from across the region, and I look forward to it.
Thank you so much, Anthony, and all our panelists for those beautiful introduction. And I think we can all be assured that this leading insolvency practitioner, and so we're going to learn a lot from them. And so we'll have our panelists respond to the question. They will each have 10 to 15 minutes. And for the attendees, you would have time for the Q&A at the end. However, please feel free to write in your question on the chat if you have any. And so without further wasting of time, I'd like to get into our discussion today. And I'll begin by dedicating my question to Wamuya. So Wamuya, normally before there's heavy rain, there are normally signs that are there. The air will change, the humidity, the winds will start shifting, we'll see the dark cloud, and we'll know that it's going to rain. And we can either take shelter to not get wet or not to be in the storm. And so when it comes to corporate distress, I'd like to ask you, what are the early signs, that normally either businesses or lawyers do not see this early warning signs? So what are those signs, and how can we as lawyers identify those signs and risk with regard to corporate distress? And also, what are the common mistakes, I would say, that happen during those early stages of detecting that corporate distress that business can face? And maybe we'd also like to hear from you. What are the protective steps that you can take in order to protect the company in that early stage of just facing financial distress? So Wamuya, karibu, we'll be happy to hear from you.
Thank you, Fatma. And so if I speak too fast, it's a sign of distress on my part. So feel free to to drop me a message. So
Sure,
simply
you'll do just fine.
Well, simply put, corporate distress is usually a situation where a company is perhaps experiencing some significant financial difficulties. And a lot of times we confuse this with a company being insolvent. But corporate distress is basically just the precursor of a company being deemed to be insolvent rather. So this is something that does not really occur suddenly. You don't wake up tomorrow and suddenly the company is in distress. It's actually something that is preceded by a series of financial, operational, legal, or even governance warning signs. For instance, if you look at a brand such as Nakumatt, which is a brand in Kenya, it collapsed primarily because there was a lot of aggressive expansion into the markets within Kenya and even outside. And obviously, there was also a lot of financial management, and therefore that led to a lot of debt burden, which was in billions of Kenya shillings. And ultimately, Nakumatt, as we all know, went down. Now, some of the early signs that a company could be in distress could be issues such as persistent cash flow problems in instances where perhaps you're not able to pay your suppliers on time, which would in turn then cause a ripple effect on other issues. And there will be supply chain challenges. You're not able to supply to your customers, which will probably cause, the loss of customers and clientele, perhaps lead to reputational damage in the business. Customers no longer have trust in you. Issues such as delayed salary payments that would, of course, have an effect on the productivity of staff members. This would open up, opportunities for staff members. We all know that in employment law that if at all there's an issue of salary delay, then that creates an issue of constructive dismissal. So that opens you up to a lot of lawsuits against the company by employees in instances where perhaps the company has an excessive debt burden. And this could be evidenced perhaps through reliance on overdraft facilities a lot, a reliance on loans to fund the operations of the company. Perhaps in instances where a company is unable to even pay the loans to banks. Even though I understand that in the insolvency industry, if a company is perhaps in a situation where they're even able to meet the interest, then that's a company that's not too badly off, and especially in this economic environment. Issues such as audit concerns. We all know that auditors, and especially in looking at financial statements on a yearly basis, they're able to pick whether companies are going concern or not, and so they're easily able to detect some of these warning signs before insolvency happens. Instances where perhaps you're working with a conglomerate of companies and perhaps management fees are due to company X and one company is not able to meet that, then that creates a strain on one business. And this will obviously have an effect on the entire conglomerate of companies. Now, some other warning signs would perhaps be even in issues to do with tax. We all know that the taxman is one of the most aggressive creditors. And so if at all you're in an instance where there are tax arrears, you're being issued with enforcement notices, then that means that the company is at a very vulnerable place. And therefore, that would be deemed to be a company that's in corporate distress. When you're looking at governance issues, and I know this happens a lot with family companies where you see a lot of poor strategic decision making because you probably have experts on board, but you're not listening to what the experts have to say, then that leads to a lot of, affects the management of the company a lot. Now, to address the question on how lawyers can identify this risk, I must say that insolvency and restructuring turnaround is one of the fields where we must appreciate that there are a lot of disciplines that come into play, not just lawyers. And I know that the jury is still out as to whether lawyers are business enablers or, a business support function. But for me, my vote is on business enablers because, again, we really play a key role when it comes to strategic decisions in the business, and corporate distress being one of them. And lawyers are some of the first professionals that would be able to see some of these signs. One, for instance, if you're looking at issues such as litigations, we are the ones who are dealing with debt collection and all that. Secondly, if at all you're sitting as a company secretary in the board of a company, then you're able to have visibility of whatever strategies that the company have in place. Again, we are aware of contractual disputes. We have visibility of perhaps whatever loans a company has, the financial information. And so if you're able to see these warning signs in good time, then we are able to assist our clients and business partners, for those of us who are in-house, to be able to implement restructuring measures, look at things such as perhaps negotiating with creditors, and avoiding formal insolvency processes as much as possible. So some of the ways that we can identify this risk would be, one, just monitoring, payments, things to do with creditor, debt demands and all that. And if you look, for instance, in the insurance industry, I mean, getting an auctioneer coming to your business one day in 2 months, that could be considered okay, usual. But if you instance where every other 2 days you have to lock your premises because there are the auctioneers at your door trying to attach, then that creates a very that means that you're in a very vulnerable position, and that's a huge red flag. Looking at loan agreements, whatever covenants that you have with banks, are you in an instance where perhaps the company is relying on short-term facilities to meet the operations of a business, because then that shows that the company is in a very precarious position. Looking at the corporate governance practices, and I know this comes into play, I'm sure my colleague Anthony will address these. If at all the company now goes into insolvency and the liquidator is looking back at the decisions that were made, are they going to find that these decisions were made properly during a board meeting, or are these decisions that were you're just ticking a box just to protect your interest as the company? Looking at whatever regulatory issues could be there or compliance issues, and you'll note that regulatory breaches would create a really bad impression. It would create financial risk as well as reputational damages, and we know that reputation is one thing that's very, very difficult to get back from the market, from your customers. Looking at ensuring that whatever regulatory fees or licenses that need to be obtained, that these are obtained in good time. Looking at things to do with tax exposure, the key commercial contracts that you have as a business. Do you have major suppliers walking out, or perhaps in instances where you want supply, they're asking for upfront payment because they've lost faith in your payment ability or the financial health of your company? Are you having things to do with cross-company risks? If at all one company is not meeting their management fees to the other, is that something to just let go? Because I mean, at the end of the day, we are still under the same management. We are sister companies. Now, those are some of the things that we as lawyers would identify, both externally and even internally, who are sitting, in board meetings. Now, having identified those risks, then there's a duty that falls on us as lawyers. One, in terms of advising our companies, the directors of our companies, and this is because depending on whatever action that you take as a company, as the directors, during this period, that could have an effect on you personally if the company is to go into insolvency. We know that in instances where there is probably preference payments, or you've sold assets at an undervalue, then if the liquidator is able to note that and such transactions are avoided, then that means that you're putting yourself in a situation where, as a director, then that liability could attach to you, because the court can pierce the corporate veil at that point. Secondly, I don't see this being done as often, but probably considering an early distress risk assessment. And in this particular case, you're looking at the company's position. Are you able to pay your debts on time? Are the creditors really aggressive? Are suppliers accepting to supply goods to the company? Is the company tax compliant? Are there any governance concerns? Are there even any cross-border exposures or even cross-company exposures that you have as a company? Now, if some of these indicators are present simultaneously, then it's important then that you just recommend immediate consideration of turnaround or just restructuring options. Because if you delay in, probably relooking at the strategy of the company, then that means that you're going into a space where you're likely to make really, really critical mistakes. And we all know that when it comes to the law, they say the ignorance of the law is no defense. So if you did it, then yeah. So I like to call these common mistakes maybe human reactions that don't necessarily align with strategic solutions that could be best for all your stakeholders. And if I were to play the devil's advocate, I mean, you've poured your heart, your sweat, your tears, your blood into a company. It wouldn't be easy to let it go, without wanting a piece of the cake. I mean, even looking at, recovery matters. For instance, for those of us in banking, even recovering one motor vehicle from a customer is usually a very tedious task, and mostly it's because you have an attachment to a human attachment to that thing, and you'd have to really look at the human aspects of it. And so one might be tempted to engage in conduct that would not necessarily delight the Lord's justices themselves. And so these are some of the, this is where as lawyers we come in. And some of these mistakes could include, for instance, preference payments, like I noted. And an example of this, you'd find that a director would probably pay off a loan to a related company or a family member just before insolvency, and just now putting them ahead of other creditors. And so if this is noted at the point the company goes into insolvency, then such transactions can be voided. Looking at issues such as fraudulent dispositions, transactions that are at an undervalue, so selling perhaps assets to just try and get as much as you can for yourself, selling an asset for an undervalue, and perhaps keeping that money, leaving other creditors unpaid, just continuing to trade while insolvent, knowing, I know under the Companies Act in a lot of countries, this is deemed to be an offense under the Companies Act. Another thing that we do, and I know there's a lot of stigma around, preferring insolvency or restructuring methods. I would say within Kenya. I don't know how the situation is in Uganda and Tanzania. But there's a lot of stigma, and so people will often not seek professional advice, perhaps from people who have experience in insolvencies. And so the more you delay with that, then it means then you're putting yourself in a situation where perhaps you may not be able to actually save the company. It's just downhill from there. Again, in terms of record keeping, again, for a board, you're supposed to be making decisions. Fatma, it seems like 2 minutes. Okay. Thank you, Fatma. So these are some of the mistakes that, or rather maybe breach of fiduciary duties for the companies, you're not acting in the best interest of the company. Now, some of the protective measures that you'd put in place, I'll divide these into two, internal restructuring measures and external restructuring measures. These do not have to happen in isolation. You can always take them, take them at the same time. We see a lot of companies moving towards redundancies and workforce reduction just as a cost-saving measure to try and reduce their overhead costs. We see a lot of companies scaling down operations, doing consolidation of business. Perhaps we hear this word a lot, austerity measures. So trying to reduce as much as possible the overhead costs. When you're looking at external restructuring methods, you can engage in informal creditor workouts where you're basically telling the creditor, this is how the situation is, and we'd probably want you to perhaps waive interest, look at a payment plan. But you can formalize it by entering into what we call standstill agreements. And basically in these agreements, you're saying, give me perhaps a 60-day moratorium so that I can reorganize my finances. Consider having an insolvency practitioner come in. I know for some banks, for instance, they have security agreements where if at all the company is in distress and before it moves into insolvency, then they can have an independent manager come in and help to, the company to just help the company with the management and all. If at all the company has idle assets, you can look at selling these assets instead of, for instance, if some of these assets are actually charged to the bank, instead of having to go through auction, consider having some private treaty sales, because that means then if you're selling at market value, you're able to recoup more than you would if enforcement was done. So I think I'll stop there. I'll address the rest in Q&A if there is any. Thank you, Fatma.
Thank you so much, Wamuya, for that detailed breakdown. And I like the fact that you pointed out that there are a number of different disciplines that would normally play a role in either detecting or handling these corporate distress signs. However, lawyers do have a very significant role. And so I agree that as lawyers, we are the one who have probably a wider overview of business operation within an entity, and we are more positioned to see these signs. Now moving on to the next panelist, as Wamuya has spoken about the early signs of distress, I think it's normally common that when people think about a company going through corporate distress, they just think you will jump into liquidation, but that is not the best practice. And so I'd like to turn to Susan and ask Susan, if you look at the regional landscape, what are the mechanisms that are normally available for businesses to preserve the operation of the business as a going concern in order to avoid liquidation? What are the things that the company can do, or steps that they can take? And what is the role of the investors, the lenders, or advisors such as lawyer would play in the business recovery process? What role do they have to play? And lastly, I'd just like to also know from you, at what stage do you now acknowledge that we should stop focusing on this rescue effort and accept that it is reasonable that we go into liquidation? So Susan, welcome. Would like to hear your responses with regard to that.
Thank you, Fatma. Some of it actually has already been touched a little by the former panelists, but I'll just highlight. I've had to engage in some of these tools, and I'll discuss about four and give some examples for the listeners to get the practical aspect. So I'll start with the informal workouts, which is an out-of-court negotiation. The moment you're faced with that, we as lawyers need not to run into court and file for, liquidation, but start with an informal workout and have negotiations. This can be held privately by the company, its lenders, the main creditors, investors, and it's not also confidence damaging to the company because it's informal. So the public is not aware of what is going on. This is just done internally between the chosen stakeholders. So why we should not go formal? In the proceedings that are formal, they basically destroy the company's confidence. Banks would start being nervous, employees start panicking. If there are any deliveries by suppliers, they'll probably stop. So the best way is to go into informal workouts. Tanzanian construction company that was owed by government, about 40 billion. Much as they had 40 billion asset laying somewhere, but then the bank loans kept falling due, and creditors kept demanding, the suppliers kept demanding. But we managed to work out a 12-month debt rescheduling, and much as it was hard, we also managed to have an interest suspension and structured installment repayments from the suppliers. So this is one of the best methods instead of running into court and into liquidation. And under this, no is required. Then secondly, another tool that we could use instead of running to court is administration. And this basically gives you a statutory breathing space, and it maximizes the value of the company. So under administration, I've looked a bit under the statutes of Kenya. It's actually embedded there. Uganda, Tanzania has administration as a tool. And then Rwanda has rehabilitation and reorganization. We don't know much about it, but this is now a formal restructuring tool that can help you instead of going into liquidation. And also a case study that we handled was a manufacturing company that was facing receivership. And it had 3,000 employees and it was 8 billion in debt. So we had to apply to the High Court, a petition, the High Court for administration, and that order was issued. We managed to keep that company trading throughout in a span of 12 months. And then we added another 6 months because we had not yet gotten invest into the company and keep it as a going concern. So, but one of the co-counsels, together with the owners, they sought investors, and within the remaining 6 months, we were able to revive the company back. So, but within the 12 months period, the company had a breathing space because we had a court order to continue the operations and continue seeking out investors to reinvest back in that company that was in distress. And then we have also another method that we can use instead of running into liquidation, and that is schemes of arrangement. This also has to be sanctioned by court. And basically, this lets a company and its creditors agree reduced debt, extended maturities, debt equity swaps. So if the maturity of a loan that a bank is actually chasing the company for is, let's say, 5 years, you negotiate with those banks to extend such maturities, so it gives the company a little bit of breathing space. But you must be able to convince the creditors in this kind of method that this restructuring plan is actually a better outcome than liquidation. An example in this case was a company that was operating in Kenya, Tanzania, Uganda, and Rwanda, and also DRC. And it had assets of about $90 million, and the debt was about $50 million. So we had to, with the other, there was a business analyst, consultant, there were auditors, company valuers, shareholders, of course, and the board of directors, all together, worked together with the lawyers to do a 10-year repayment plan. Then they also reduced interest rate, and part of the debt was converted into equity. And this was sanctioned by court, and as I speak, the company is actually a going concern. Then another tool that we have used is a sale and lease back. This was it was just one of the Sundays in the afternoon, someone consulted and said, you know, I have a company, but my employees are threatening to sue. I failed to pay the employees. And then suppliers are also on my case. And then we do not have money to buy the raw materials to company. And it's locally owned by two Tanzanian, actually, husband and a wife. So we thought actually at the beginning when we took the case that it's just trying to see how we can manage the employee suits and all that. But later we came to realize actually it was worse than that. But the company was still, we were still able to gauge that the company can be saved. So during one of the meetings, someone said, someone actually is looking at land in that semi-prime area where your manufacturing facility is. So they said, yeah, I think we were able to sell. So we are able to sell it if they are okay to buy it. So we used the sell and lease back method to be able to save this company. What happened? The other person actually bought the factory land, but then these people, we drafted sell agreements for sell and purchase agreement, and then we also drafted lease agreement. They were able to lease back that property. And they actually paid rent for like 1 year. They were able to buy the raw materials. They were able to pay the employees and some suppliers, but they just have to reduce the employees. They had to do some retrenchment for some employees because they were also overstaffed at that level. So we used sell and lease back method, and it worked, and the company is also a going concern. So there's also equity injection and recapitalization, and while doing the informal workout and or formal workout, you can still use the equity injection and recapitalization. So it all depends on at which level the company is. And I'll discuss briefly how each approach is a success. When you use informal workouts, you have maximum flexibility because you're doing negotiations with stakeholders. There are no court proceedings, so it always saves time, and then there's no publicity, and it reduces panic. Even if the bank is demanding some facilities you've not yet paid, there would be no banks in knowledge of what the company is going through. Then as for administration, there is protection from the creditor's action, the multiple suits from this side and that side. The company rests from the pressure. Trading also would continue under control. And under schemes of arrangement, the business continues unlike liquidation. Employees remain employed and customers are still retained instead of going to the competitors. So how do we coordinate the cross-border restructuring as lawyers? I would give an example of one of the entities that had a parent company in Tanzania, and then subsidiaries in Kenya, Uganda, Rwanda, and DRC. This is a vivid case, and the Kenyan lenders had sought administration. The Tanzanian lender had appointed a receiver. Then Ugandan suppliers were commencing suits, and DRC tax authority were freezing their accounts. So what we had to do here was to identify the lead jurisdiction and where that management sat, where the strategic decisions were being made. Then we had to secure some standstill agreements so that there is no further enforcement and lawsuits. We also established creditor coordination and recognized local risks. For example, in Tanzania, we realized that TRA is very critical. Tanzania Revenue Authority is critical. And also in Kenya, we knew that the secured lenders were holding leverage. Okay. Then we did coordination with court proceedings as we had administration in two jurisdictions filed. So we contacted the lawyers the other side and worked together to see that the courts were actually unified. And one thing that we're looking for is to coordinate all creditors and courts to be under one roof so that we could manage such a problem. So what the lawyer needs to advise, or the role of, you asked, sorry, Fatma, did you ask the role of investors or the role of lawyers?
So I just asked that the role of what the lawyers, the investors, or other advisors would play in that recovery process. I think you've somehow touched on it.
Okay.
Yes, but maybe just the other question that I'd asked is, at what stage do you realize that you need to maybe now go into liquidation and maybe all these rescue mechanisms are failing?
Okay, if there is persistent cash shortage, despite the reported profits, we just have to recognize that that time it's a time to do liquidation. If you have inability completely to pay the suppliers and you've tried all the informal workouts and they're not working, you've looked for investors and they're nowhere to be seen. Then if the taxes are also growing and you don't have any way out, you don't have any debtors in your radar, and also if you're rising the overdraft utilization, and also the other issues, if you're rising your overdraft utilization and you're unable to pay every time you rise it, then it's a sign that actually you're almost going into liquidation and it's hard to save such a company. Yeah.
Thank you so much, Susan, for sharing those, I would say, strategic and legal ways in which you can try to intervene in order to save the company. And I think you must be good at engaging creditors and coordinating, because from what you're sharing, I'm learning that you have been involved in situation whereby you had multiple creditors and you're able to bring them together to discuss on how best you can proceed forward with the company. So thank you so much. And I think as Susan was sharing, that once the company has faced financial distress, it will normally go through various mechanisms. Not always, but ideally, that is what would hope. I think most of the time people do not detect the corporate distress early. And so by the time they come to realize it's quite too late, time is of essence when it comes to corporate distress and insolvency matters. And so I'd like to move on to the next panelist, Mr. Isaac. And I think when we move from restructuring and going into liquidation, normally creditors are one among the group of, I would say, stakeholders that are normally very concerned, and they normally want to be paid as fast as possible. And so as we're looking into cross-border, Mr. Isaac, I'd like to ask you, whereby we have assets and creditors from different jurisdictions, what are the common practical challenges that you would face when you're a liquidator or when you're a lawyer for the company in dealing with this? And what are the common dispute that arises in this scenario? And you can tell us maybe with regard to the ranking of the creditor, how will that go, or how should that be handled? And if there are any court decisions, maybe that speaks to that. But I also like to hear with regard to secured creditors. So I'm a secured creditor. I know this company has certain asset in another jurisdiction. How can I be able maybe to get my recovery from that? And so karibu sana, Mr. Isaac, who would like to hear from you.
Sorry, Fatima, asante sana. My apologies that my voice has just decided to rebel, and so it's gone down. I don't know why, but I'll try. I hope the audience will try to get what I can talk about with this low voice now.
We can hear you just fine, and pole sana.
Okay. So let me start by stating that at least in East Africa, we don't have a harmonized insolvency law. And this is the biggest challenge for every creditor that is trying to recover his or her debt from the assets located in another jurisdiction. this is very difficult. As of today, the general principle is that the law of the place where the assets are located will govern how a foreigner or anyone will place a hand on that asset. And so it's a process. Before you can even think of going abroad to recover your money from the assets of the debtor, you need first to be recognized from your home jurisdiction. It is not sufficient that you have a contract and you can carry that contract and go and attach the asset of the debtor. Remember that we are talking, our subject is about insolvency. And the purpose of the law, insolvency law, is protect the creditor, but also the debtor as well. And until recently, only there was no opportunity for the debtor in cases a corporate entity. There was no opportunity for under the law to be protected as such. But today, we thank God that as the evolution of insolvency law has gone, now the assets of the debtor are protected by the law, and in many jurisdictions, including at least East African jurisdiction, the first priority of an insolvency administrator who is appointed to oversee the operations of that insolvent company or entity is to see how that company can be revived, reorganized, and continue operating as a going concern. So this is a good protection that the insolvency law in East Africa, and at least I think in most of the jurisdictions, has come up. So the fact that you have, as a creditor, you have the right to claim from the debtor, you need first to wait and your time comes up. So the first time, if the company who is the debtor, if it has applied for reorganization, then it will have a moratorium or a protection period to allow itself, its management, to prepare a organization plan so that it can continue operating as a going concern. The goods and the bads of that is that the moment the court grants that application, then every creditor's hand is stayed away from the assets of that company. And that is including the secured creditor. But for secured creditor that here in Rwanda, there is a moratorium given is about 6 months maximum. But at that time, when within 6 months, when the creditors vote for the organization, then even the secured creditor will not have a hand, will not place a hand on the assets of that company. So going abroad now to try to recover, you just have first to satisfy that the distressed company or debtor is not in the organization and it is in liquidation, or the moratorium period for you, particularly as a secured creditor, has expired, and then you can pursue the assets of the debtor. But I think when you're talking of recovering the assets, when talking of going abroad to recover the assets there, I think that at this time we are not talking of a secured creditor, because a secured creditor, for him to have to be considered secured, it means that he has a legal charge on the assets of the debtor, that are due when circumstances under the law have crystallized. And so you may find that when you go out, when a creditor has a Rwandan creditor is trying to pursue the assets in Tanzania. For example, the Rwandan debtor has gone into insolvency. At the time he went into insolvency, he had about probably 10 containers of goods coming from China, and they are destined, the port of discharge is in Dar es Salaam. And so this creditor will probably try to stay, to keep those goods in Tanzania, at the port of Tanzania, and prevent them from coming to Rwanda, or even try to sell them in Tanzania, or divert the routes from being destined to Rwanda, and they are taken probably to Uganda. So at that time now, the challenge here is that this creditor has to present himself or herself to the Tanzanian authorities to prove that he is a bona fide creditor and recognized in his or her home jurisdiction, and that he has the right to pursue the assets of the debtor wherever they are. And so the authorities in Tanzania will first undertake a process of recognition, and so that they can permit this creditor to basically to place the hand on the assets of the debtor. But he cannot do that in Tanzania. He has to find an insurance practitioner, I don't know how they call them in Tanzania, so that this practitioner is appointed and to do the recovery. And then he is going to play to do the seizure of those assets. He can either, at the instruction of the creditor, either decide to sell them or direct where they can be taken. And the sale of those assets has to be made in transparent manner, because they may probably, the debtor may be owed maybe $500,000, and the value of those goods is about $3 million. So this means that the insurance practitioner in Tanzania has to discharge, to dispose of those assets, those goods, in transparent manner, so that the surplus is given back to the debtor to be able to satisfy other creditors. So what I wanted to respond to your question here is it's a process that a creditor cannot simply fly and go looking at the assets of the debtor wherever they are. First, it must be recognized. You are in your home country as bona fide creditor. You must go to that foreign jurisdiction, seek recognition, and have the insolvency practitioner or a receiver or a debtor, whoever, appointed, and those goods, those assets, or the management of those assets is made in accordance with the laws of Tanzania. I mean, as an example that I get. So you may find that the laws in Tanzania are completely different, and they may not necessarily permit or satisfy the creditor in the way that he wants. Because if the goods, for example, they are fixed assets, if it is a land. So in that case, it has there are other creditors who are going to emerge on that asset when a foreign creditor purchase it. So what I wanted to say that it's not a straightforward process, but of course there's a high cost involved, which must be incurred by this creditor to go. There's investigation. You have to hire private investigators who have to go do the search, do the local search in the registry of lands, in the banks, anyway. So it's not a simple task. I want to give an example of that particular situation. So I have been liquidating a company since 2021 to since 2022, and this company had a parent company in the UAE, and this parent company UAE owed this company here in Rwanda about $6 million. But in the process, about 3 were recovered. Then they were paid voluntarily, and 3 remains outstanding. And what happened is that, to be honest, I have failed to recover now. In the process, when I was in the process of trying to approach to find the lawyers in UAE who can help me, then even the parent company went into administration, and it was taken over at a price of $1. So another company bought it at $1, and I could not. It changed the name, it changed everything, and I've completely failed. I had to declare this to the creditors that I'm abandoning this recovery, and I cannot be able to recover that because of the cost involved. So in terms of priorities of creditors, it will depend on jurisdictions, but what I can say is that they all share the same, they almost share the same ranking. First is secured creditor. And when I talk of secured creditor, I'm not talking of the fees and the cost of administration. Those are primary before even secured creditor is paid. After the secured credit is paid, then there's preferential creditors, then employees, then taxes, government taxes, then unsecured creditors, and then the debtor who can get the surplus if it is there. I think this is what I can say on the part of banking, at least in East Africa, and the challenges that a creditor can face when he's trying to recover from the assets of the debtor abroad. Over to you, Fatima.
Thank you, Isaac. Just a quick question with regard to the ranking of the creditors. Does the employee come before statutory creditors in Rwanda, or?
No.
Okay.
Statutory creditors, they come first whatsoever. Remember the staff have been paid from the man of the secured lender. So the staff, the employees are actually in Rwanda. They are the fourth. They are the fourth. Yes.
Okay. Okay. Just I had thought you had said they're above, but thank you for that clarification. And thank you so much for taking us through the practical challenges with cross-border insolvency in East Africa. And I think when you're explaining it, it's clear that we need to think about how we can have a better way of handling cross-border insolvency within the East Africa region, rather than how fragmented it is right now. So thank you so much. I'd like to move to our next panelist, Mr. Anthony. And I think, Anthony, we had heard from Wamuyu, who spoke about financial distress. And we've heard about company going into insolvency. And so when we look at the directors and certain officers of the company, they will normally be in play in making decision. And I think there's a very fine line between a director or a board trying to make decision to save the company and them doing wrongful action or taking certain decision that would have impact. So would like to hear from you, one, to the directors of the company, does their responsibility ever shift from just protecting shareholders' interest to now maybe protecting creditor or other stakeholders? Does that responsibility shift when the company is undergoing insolvency? And would also want to hear what are the most common mistakes that the board or directors would make when the company is undergoing insolvency or when facing financial distress. And as lawyers, how can we better advise them or guide them? And what sort of liability are they normally exposed? Personal liability, either as directors or officers of the company when they're making this decision throughout? And if there are any safeguards that you think should be kept in place when the company is now maybe facing, whether going through restructuring or insolvency, if there are any safeguards that maybe should be considered in order to ensure that the directors or officers and do not fall into this pitfall. So welcome, and we'd like to hear from you.
Thank you so much, Fatma. So as you said, really mine is to speak about when and if directors do not heed the early warning signs my colleague Wamuyu was talking about, what liability accrues to them. So firstly, before I even begin, to your question, responsibility during insolvency is to the shareholder, but responsibility during insolvency is to the creditors. So that in taking you through my answers to your various questions, I would just have 5 points. So the first one would be, it is interesting to note that the legal landscape around in East Africa appreciates that directors may, in certain instances, before leading to insolvency, not either negligently, recklessly, or with intent, not pay attention to the early warning signs. So that the question that arises is, when does a risk crystallize to the directors so that they can be held personally liable? Because they often realize that when it's too late. So firstly, just want to mention that if you look at, for example, the Kenya statutory framework, we of course start, the risk crystallizes because directors have a duty. And if you look at the framework in Kenya, in Uganda, in Tanzania, the duties of directors is properly enumerated in the various statutes. So for example, in Kenya, you have section 141 to 147 of the Companies Act that lists duties of director. In Tanzania, you have section 185 to 188. And in Uganda, you have section 198, 199, and others. So that if a director breaches this fiduciary duty in either negligently or recklessly or with intent, failing to take care of the company's affairs, what liability can crystallize? So that again, before I move on to the second point, you would find that the various jurisdictions I've talked about have enumerated in their statutes what this action would be, what this action that the directors would take that would lead now to personal liability would take. So for example, in Kenya, we have wrongful trading, fraudulent trading, unfair preferences. And these are points that I will be enumerating within the presentation, so that you have wrongful trading, which connotes an element of negligent or reckless behavior on the part of directors. We all have clients who have, for example, been directors in companies that they have no idea what they do until trouble comes. And this would now connote the activity that this director would be guilty of. Now, fraudulent trading in Kenya is enumerated in Section 1002 of the Companies Act, and it connotes intent, premeditated intent to defraud a party. It can be a bank. It also carries criminal repercussions. And I'll be talking about that in some case studies that we will get to. We also have unfair preferences and voidable transactions. Now, this, I think, one of the speakers touched on. When a company is going into insolvency and those warning signs are there, directors are tempted. I think, as Wamui said, sometimes these directors are founders. They have spent their blood, sweat, and tears, and they are tempted to recover some amounts or create some preferential treatment to some related party companies or to some third parties with an intent to prefer them over other creditors. And that is also a wrongful act that in all jurisdictions, especially Kenya, Uganda, Tanzania, is conduct that is that can lead to personal liability accruing on the directors. So without going through again the statutory frameworks in those jurisdictions, let's move to speak on what are the common mistakes that directors do when they before that liability accrues. So number one, if you look at, for example, wrongful trading, what is wrongful trading? It is an aspect that can be described as when a company was insolvent or became insolvent and continues trading. Now, you have seen the warning signs, yet you continue trading. You ought to have known. In fact, you don't have to know, but you ought to have known. And this is where now the courts and the liquidator and the administrator in these various jurisdictions, once they go through the books, once they go through the transactions that the company did, will they find that you ought to have known? And now wrongful trading, in some examples that I'll give, has led to directors being held personally liable because you ought to have known. And for fraudulent trading, it connotes an issue of intention. Now, for example, you have seen the warning signs, and yet you continue to ask a creditor to give you a facility. Now, what liability will accrue on a director once either the court, a liquidator, or another insolvency practitioner is going through the history of the company once it is insolvent, either in administration or liquidation, and finds certain actions that can constitute fraudulent trading. You have breach of fiduciary duty. Breach of fiduciary duty also can lead to personal liability accruing. Breach of fiduciary duty, as I've said, is properly crystallized in all jurisdictions. All the various statutes that govern the formation, administration, and management of companies in all our various countries does have fiduciary duties that directors must abide by, so that it is on the directors themselves to be proactive in managing the company's affairs before it leads to a situation where they can be held personally liable. For example, in one of the few cases of fraudulent preferences, or in company that saw itself going into insolvency and created certain assignments that the court did in its holding constitute as preferential treatment. Now, it's the case of Malde Holdings. It's 2024 EKLR. Now, that is E-Kenya Law Reports. Now, in that case, a company that was heading into insolvency, it is said in the case, had assigned its only income, which was rental income from a related party company, to pay the directors' loans. That is over the secured creditors, because they had secured creditors. That is over all other creditors. Now, once the company went into administration and the administrator went through the history of the the administrator noticed a transaction and he moved the court under the Insolvency Act. That should be section 383, 384, 385. Sorry, 683, 684, 685 of the Insolvency Act, and move the court to annul and reverse those assignments. And the court did. Now, what you'll find in these cases where directors are to be held personally liable, it is conduct that is, it is not wrong for a company to be insolvent. I think that is what courts in all jurisdictions have said in our region. What is an issue is that a company that is insolvent, its directors acting in a manner that would want to defeat other creditors in terms of either preferring certain transactions to related parties, in terms of continuing to trade, yet the company is going insolvent, or in terms of negligently and recklessly continuing to trade. Now, that is the issue that courts and insolvency practitioners have dealt with. Now, I have shared my write-up with the organizers, and I'm sure it will be shared. So I won't go through every case that we mentioned in the case study, but in all jurisdictions, we found case law where directors have been held personally liable for these three major reasons. Now, one thing that I would want to talk about in terms of cross-border pursuit of directors, as my fellow panelists have said, East Africa does not enjoy a framework throughout the region on insolvency. Different jurisdictions have different statutory frameworks that they work with. And maybe this is something as insolvency practitioners in the region we should champion, which is a framework of committee that would allow us as practitioners to better pursue debtors, or even these directors who would hide money in different jurisdictions, knowing the tedious exercise it would be for both creditors and us as practitioners to chase them across borders. And even as the East African Law Society to champion a uniform insolvency framework in the region. Now, for example, if you look at the European Union, they have insolvency regulation of 2015. Now, this is shared across all member states so that it has various features that would allow practitioners or insolvency proceedings to proceed with a form of committee across the region. Now, its main characteristic is something called COMI, which is the center of main interest. Now, as Nelima said when she was mentioning an example of a client who had the business in various countries in the region. In these regulations, it would allow for the creditor to file for insolvency against that business, either administration or liquidation, in the center of main interest. That would be the country where the company is most prevalent. So that once it files in that company, the other insolvency proceedings that would be filed in the other countries where the company that is the target has business or has a presence would only be to manage those assets. So that in that framework, it would be easier when you have directors who are actively cheating creditors who follow them through the various countries. Because in our instance, if you have a director who's fraudulently trading in Kenya or wrongfully trading, or has preferred or has moved assets from one place, from one country to another, it would be difficult and very tedious for creditors to move through the various countries and chase them. So that's maybe something we could think about. Now, when we come to another aspect of directors' liability would be the registration of them as directors. For example, they could be disqualified as people who could hold directorships in various companies in the country. That's an liability that can accrue. For example, in Kenya, if the court or the insolvency practitioner moves the court can disqualify someone from being a director due to this reason that I've talked about for 10 to 15 years. That's another liability that can accrue. Now, us as lawyers, what is our job here? The advice we would give the directors so as to make them properly aware of how liability can accrue to them would be one, to make sure that they are alive to the business or the activities that the company is undertaking. Don't be an absent director. And that would mean what? That would mean be active in board meetings, document everything. Because as I've said, once the court or the insolvency practitioner takes charge of a company, they would investigate this past dealings. And investigating them, they will come across instances where it would be deemed wrongful, fraudulent trading. So make sure we advise our clients to document everything. They could also start early restructuring, as Wamuyu has talked about, as Nelima has talked about. They could, in Kenya, for example, undertake voluntary insolvency proceedings. They could also resign from the board if they do not think the board is undertaking its duties in a manner that would shield them from this future liability. They could keep proper books. All in all, all jurisdictions that in our region have a statutory framework that directors can be held liable. So it is our job to advise them how not to and how to better lead their companies. Thank you, Fabi.
Thank you, Anthony, for that very clear explanation with regard to the legal exposure that directors and officers of the company would normally face and the role that lawyers would play. And I think it's clear normally as lawyers, we are probably involved with the boards or we're giving advice to the company. And so we all have a role to ensure that the boards and the company are properly informed with regard to decision making when they're going through the process of either restructuring or insolvency, and to ensure that the directors and the officers do not face personal liability, because I think it will be very difficult to defend themselves. So thank you so much, Anthony.
Thank you.
We're moving on to our last panelist, who is going to talk about asset tracing and recovery across borders. I think one of the difficult tasks when it comes to insolvency is being able to trace asset across borders. I think even if it's within your jurisdiction, it might be very difficult because it's easy sometimes for this asset to either be transferred, moved very easily. And so turning to Noella, maybe joined by Mr. Odera, would like to hear from you. What are the effective strategies for asset tracing in insolvency processes? And what methods or technique do you normally use when doing this and taking into account when there's cross-border aspect in play? And would also like to know what legal remedies are available to a company who wants, or to a liquidator who wants to trace assets in various jurisdictions. So karibuni sana for your presentation.
Thank you very much. As I had mentioned, I was standing in place of Mr. Chacha Odera, Senior Counsel, who was engaged in court. He has now appeared, and he has kindly allowed me to continue with the presentation, and so I will proceed. Thank you, Fatma. I had been requested to speak on the practical steps for identifying, freezing, and recovering assets that have been moved out of jurisdiction. And I think I will start by basically defining a few key concepts. And one of them is asset tracing, which is basically identifying and locating assets that should be subject to the insolvency proceedings. And asset recovery is returning those assets back into the insolvency estate. Now, usually when you have established liability, that is just half the war. The real battle comes in trying to trace assets that have either been dissipated deliberately or fragmented or have been concealed with a view to frustrating any insolvency efforts that are taken with a view to recovering or tracing those assets. Now, in the context of a cross-border matter, a lot of value is held in various structures, including but not limited to regional subsidiaries, branch structures or offshore accounts, receivables, intellectual property, as well as intercompany payment chains. And so the real task of a legal practitioner is to first identify where those assets are, and then once he has identified where those assets are, preserve them, and then put enough effort into recovering those assets so that they become part of the insolvency estate, and thereafter distribute them accordingly if distribution is where we are headed to. Now, the framework for cross-border insolvency in some African jurisdictions who have adopted it is UNCITRAL, which is the model law on cross-border insolvency. Kenya has incorporated it by reference, and it is recognized through the Insolvency Act from Section 720 going onwards. I think the only other East African country that has adopted the UNCITRAL model is Uganda. Which therefore means, and we will talk about some of the challenges, that not all the East African countries and not the entire of Africa can have a seamless cooperation when it comes to asset tracing and cross-border insolvency. And the main principles that the UNCITRAL model follows is, first of all, granting you access into a foreign jurisdiction. And then once you get into that foreign jurisdiction, you need to be recognized, or your foreign insolvency proceedings and the foreign insolvency representative need to attain formal recognition, normally from the courts of that country. Once they attain formal recognition and access, the next thing is to then seek specific relief that you want in that particular foreign jurisdiction. And the relief may range. It may be a stay order, it may be a freezing order, it may be suspension of proceedings, etc. And then once relief is obtained, the next practical thing that needs to be done is cooperation between the foreign proceedings and the proceedings in the main country, so that then you have some seamless sort of insolvency proceedings with creditors that are in a foreign country and creditors in the main area of insolvency all being coordinated together. So an effective cross-border recovery is achieved through a sequence or a combination of steps, and one of them is to identify. And identification of assets is done through various tools, but it can also just be done through getting a PI, that is a private investigator or an inquiry agent, to give you an investigation report as to the location of those assets. We will speak about other legal tools that you can use, such as the Norwich Pharmacol and the Bankers Trust orders. And then, of course, we spoke about once you have managed to trace or identify those assets, you then need to preserve them, particularly where you have flagged a risk of dissipation of those assets. And there are various ways that you can freeze assets. You can use a Mareva injunction, you can use insolvency moratoriums that are available. If it's an administration in Kenya, it gives you an automatic moratorium. So assets cannot be disposed of or transferred without either leave of the insolvency practitioner that is managing the process or leave of the courts. And then, of course, there is recovery. And you then can utilize other frameworks such as the mutual legal assistance frameworks and the UNCITRAL recognition process that is set out in various statutes. Now, if we are to touch on the Norwich Pharmacal orders, this particular order originates from an actual case, which was Norwich Pharmacal versus Customs and Excise. And the fact of that case is that basically one of the parties, the applicant, needed very critical information to enable them know who to sue for purposes of wrongful conduct. And so they needed the information from the customs officials. And so they made an application that even though there was no liability that attached to the customs officials of England, they had certain critical information that would disclose the identity of who they would have to sue for purposes of the wrong that had been done to them. So the purpose of a Norwich Pharmacal, as it states there, it compels an innocent third party who is caught up in wrongdoing to disclose information needed to identify and sue the ultimate wrongdoer. And the three conditions that the court will normally require you to prove if you are making this application is one, that a wrong has been committed or you have an arguable case that a breach or a wrong has been carried out. And then the order is needed to enable action against the wrongdoer. And that order is normally directed against an innocent party, whether it's to disclose or to identify. And then the third thing is that the respondent facilitated, so the person you're trying to seek that information from either facilitated or was involved in the wrongdoing and can provide some necessary information that will enable you to ultimately then lodge your action against the wrongdoer. And that particular Norwich Pharmacal orders have been issued successfully in Kenya. And the case in point is Palm Oil Transporters Limited versus Kenfright East Africa Limited. And again, this was the same sort of scenario. An order was directed to the Kenya Revenue Authority to produce electronic documents regarding some cargo movement. The facts of that case is that the cargo had either been misappropriated fraudulently or had been lost. And to enable the owner of the cargo establish if and whether it has to sue someone, it needed the electronic documents record from the KRA. And so this particular case demonstrates that third-party disclosures are essential in tracing asset transactions and identifying movement. There are certain limitations in using the Norwich Pharmacal case. It's not available against someone who's a mere witness or a defendant. It can't be used to secure or obtain evidence, and it cannot aid in a foreign proceedings where there is already a statutory regime in the foreign country for how to obtain that evidence. So the other tool that you can use is what we refer to as Bankers Trust orders. And as the name suggests, this is also from a case called Bankers Trust Company versus Shapira and others. And the brief facts of the case are pretty much very straightforward. The bank and the customer had entered into a contract pursuant to which the customer owed the bank some money. The bank got wind of some information that the customer was about to dissipate some of the funds. And so the court stepped in by giving this particular order of disclosure of certain information. And I think the key point in this case is that it circumvents, or it allows you to, for the moment, disregard banking confidentiality, which, as you all know, is the bedrock of banking practice. And it says there that some of the things that are taken into consideration is ownership. There must be some strong evidence that the funds belonged to the applicant. And then there is evidence of dissipation or fraud, which is the funds were fraudulently dissipated, and that the information sought will lead to locating or preserving those funds, and that there is some urgency in the disclosure. And it may be requested both prior to or after the institution of proceedings. And if ordered, as I mentioned, it supersedes the duties of banking confidentiality, so the banks cannot hide behind the confidentiality obligation once an order, a banker's trust order, has been issued. and the applicant may be required by the court to undertake that the information will not be disclosed, save only for purposes of tracing the funds. So that's the second tool you can use. And then one that we are mostly familiar with is Mareva injunctions. Again, the name derives itself from the Mareva Compania case. And this case, if some of you recall, it's about a charter party, a charterer and a shipper. And in that case, they had the charterer had a claim against the person that had chartered its ship, and they got wind that that particular party was trying to dissipate its assets with a view to avoiding a valid judgment that had been entered against them. And as you can see there, Lord Birmingham in Fury says about Mareva injunctions that they are granted for an important but very limited purpose. That is to prevent a defendant from dissipating his assets with the intention or effect of frustrating enforcement of a prospective judgment, and they are not a proprietary remedy. And the main grounds that need to be illustrated is you have an arguable case and that there is a real risk of dissipation if preservation orders are not ordered. In practice, it's considered a draconian kind of order to freeze someone's assets pending, the issuance of a judgment or the determination of a case. And courts will be reluctant to give this order unless you meet the very high threshold for proving the conditions for grant of this particular order. We've set out on our slides a number of cases in Kenya where the courts have found that this particular order was warranted, and you can see them there. Now, one of the other procedures that you can apply in Kenya is the one we've talked about, which is recognition of foreign proceedings. And what that means, essentially, it is an insolvency practitioner in another country has realized that some of the assets or a majority of the assets of the insolvent entity sit in another country and are held by a subsidiary or a branch or a parent of or an affiliate of the company that is insolvent. And in such cases, what will happen in Kenya at least, and I'll speak about Kenya, and I think the same would apply to Uganda because they have adopted the UNCITRAL, is the foreign representative will make an application to the High Court. And what is key is what must accompany this application. Usually it is a certified copy of a decision commencing foreign proceedings in the foreign country and a certificate from the foreign court affirming those proceedings or any other evidence of those proceedings. And the courts will generally recognize this foreign representative as well as the foreign proceeding if the proceedings meet the definitions of a proceeding within the meaning of the Insolvency Act, and if the applicant is recognized in the foreign country as a foreign representative. And then, of course, if you meet the procedural requirements, which are the documents that have been set out there. And I think the key issues that arise in a recognition is what we call main versus non-main proceedings. So foreign main proceedings are based on insolvency proceedings that are commenced in the debtor's center of main interest. And in that case, you get an automatic relief of a stay of execution, so that if Kenya is, for instance, the center of main interest of the debtor, once the insolvency practitioner is recognized and the foreign insolvency proceedings are recognized, you get automatic stay of execution, disposal, suspension. However, if it's not the proceedings are not the main center of the insolvent place of interest, then you will have the court has some discretion in giving some of these orders, like stay of execution, suspension of proceedings, etc. And in Kenya, the courts can refuse to give recognition to a foreign insolvency representative or for foreign proceedings if the action is deemed to be manifestly contrary to public policy. And that whole idea of what constitutes public policy, what is repugnant to morality and justice within the Kenyan constitution, etc., all that is discussed at great length in the case of CNC de Ravenna, which was decided by Justice Tuyot, who is now a Supreme Court judge.
Court of Appeal.
Court of Appeal judge, sorry, Court of Appeal judge. So what are the effects of recognition? So effects of recognition of foreign proceedings include you can get a stay of individual actions concerning the debtor's assets, and you can also get a stay of execution of the debtor's assets, and you get a suspension of the transfer or disposal of the debtor's assets. And then the discretionary relief, which can be granted, is the court may stay. So this is not automatic. Execution or suspend disposal of rights. It may also order examination of witnesses and delivery of information, and it may entrust administration of the Kenyan assets to the foreign representative. Now, the relevant provisions also provide for the protection of creditors. And it has a mandate, the court has an obligation to ensure that the interests of creditors and other parties are adequately protected. And in doing so, the court may impose conditions on any reliefs that it grants. And it also gives an order, which is basically liberty to apply, which means that any relief may be modified or terminated on application. Any foreign proceedings or a foreign representative who is recognized would be able to apply to set aside transactions that may be called preferences through the doctrine of relation back. So they'd be able to exercise a lot of the rights and entitlements that you will find in the Insolvency Act. And I think Miano spoke about some of these. So when you talk about mutual legal assistance, in Kenya, we have a Mutual Legal Assistance Act. And I think most of the MLAs that we have looked at, and we won't speak a lot about them, seem to be limited to fraudulent, criminal, corruption, money laundering, or criminal actions. So there is very limited room, at least in my view, for an insolvency practitioner who's looking to secure assets with a view to satisfying an insolvency estate to use MLAs, because the legal regime for MLAs within Africa seems to limit themselves to the recovery of public funds mainly, and it seems to be administered by the attorney generals of the respective states in which the mutual legal assistance is required, and you have to be certified as a competent authority that can then request for that assistance from another state, because mutual legal assistance is usually a public entity of one state asking another state to assist it in basically securing evidence or arresting people that were involved in criminal actions or freezing assets that were involved in any criminal wrongdoing. So what I would say is that there is very limited application of the MLA within the insolvency framework. Of course, we have foreign judgments enforcement. So where you have a foreign judgment and you want to enforce it in Kenya, one of the things you can look at, we have the New York Convention.
I'm sorry to intervene, but you have 2 minutes left.
I'm actually on my last slide.
Okay.
So if you can go back, Kate, I think one of the things that I just wanted to point out is that's an emerging area that we probably want to look a bit more closely in is when you are conducting asset tracing with respect to digital assets. This is when you're trying to trace cryptocurrency through digital wallets or tokenized assets, etc. I think it's one of the areas that there's still very little in terms of how will the courts react. Will they consider cryptocurrency property capable of being traced and enforced to satisfy a judgment? So that's one of the areas I think that we can look at. But to close, essentially, our closing remarks are that asset tracing and recovery is at the center of modern cross-border insolvency practice. Some of the legal tools that you can use is Norwich Chronicle Order, Bankers Trust Orders, Mareva Injunctions, MLA, and the unsealed trial recognition process. Speed, coordination, judicial cooperation, and strategic deployment are decisive factors. And given that East Africa is a growing market, it makes cross-border insolvency cooperation essential rather than just optional. And of course, it depends very very, very wholly on cooperation between various states and countries. And I think I will stop there. I don't know if Chacha wants to say something before I say.
I don't have much to add on to. Thank you very much, Noella. The only thing, Fatma, which we will offer is that there's a lot to be said about the topic of this afternoon. And we did prepare a paper which we will share with you, and you can share them with the participants. Thank you very much for having us.
Thank you.
Thank you so much, Noella and Mr. Odera, for that presentation. And I'm happy to hear there's a paper. I'm sure a participant will benefit a lot from it. And thank you so much for taking us through those legal mechanisms that we can use in asset tracing and recovery. I think you did point out that only Kenya and Uganda have adopted the UNICITRO law. And I'm wondering to the panelists, maybe when you open the QA, should we as East Africa consider adopting UNICITRO across all countries, and will that solve our cross-border insolvency challenge? Or what are your thoughts on how we can go ahead with regard to cross-border insolvency in East Africa? We're going to move into the questions. If you have any question, I think you can raise your hand, and maybe Gabriel or someone from the East Africa Law Society will then mute you. But I had seen a couple of questions already in the chat. I think some of them are answered. Yes, so I think some of them are answered in the chat. I don't know if there's anyone who has a question and would like to raise it. But the first question that was in the chat is how different is an interim liquidator and an administrator or a statutory manager, and do they play the same role? I will invite Susan to briefly respond. I know she has responded in the chat. And then the next question was to Anthony on who is when an administrator incurs expenses but pays after an interim liquidator is appointed, is he held personally liable? Anthony has also responded in the chat, but maybe we'll give him just a few minutes to also respond to that. And the last question was, it is good practice to appoint interim liquidators who can't fully wind up the company, but decimating the assets of the company through his fees to the detriment of the entire body of creditors. That was a question, and maybe I've seen Susan and Wamuya have responded, but I'll invite Wamuya to respond to it just briefly. So I'd like to, if there's no anyone who has a question, then I will invite Susan to respond to that first question, just briefly.
Thank you. So for interim is appointed basically to protect the assets of the company when a court smells that maybe there will be a mismanagement, and this can be suo motu. We've seen some courts actually they're the ones who initiate this kind of interim appointment, or anyone can bring an application to say that the company assets are in danger or they'll be mismanaged. So they usually appointment is pending, like a winding up petition. And then for administrators, we already discussed, this one is appointed also by court to purely rescue the business. For a period, for Tanzania, it's a period of 12 months. But if you feel as an administrator that 12 months are not enough, usually you could go and do an extension of probably 6 months, but with the reasons to back your extension. And then the statutory manager for Tanzania, it's appointed by, it's appointed for regulated institutions. For example, the insurance companies under the Tanzania Insurance Regulatory Authority and the Insurance Act. And then also the banks under the Banking and Institutions Act and regulations. Yeah, so that's the difference. Thank you.
Thank you, Susan, for explaining those differences. I'd like to invite Anthony to briefly respond to the question.
Thank you, Fatma. So just briefly, administration and liquidation expenses have a priority in at least the Kenyan jurisdiction in terms of priority payments. So the first of the process that obtained from the company that is either under liquidation or administration goes straight for those expenses. So that in that sense, no, they will not be held personally liable. But it is something as a practitioner I do come across a lot in the various companies or cases where I'm involved in companies that are in liquidation and administration. When the administrator issues the report, you find that they've spent close to 20 to 27 million to 30 million, crazy amounts of money on managing the company, while the creditors themselves have obtained nothing. So it's also an irritation I have with our current framework, but it's something we can talk about, I think, a bit more later. But I can give time to Nelima and Wamuye to answer the next question.
So Anthony, before you go off, there was another question just written right now, whereby they're asking, at what point does a lawyer advising a distressed company have a duty to proactively tell the directors that they need their own separate counsel? And is there a professional conduct obligation there?
Well, in practice, what happens is until the veil is lifted is when you would have directors personally appointing their own lawyers. But before then, any application in court by either a creditor, a liquidator, an administrator would still be defended by the company's counsel. But it is a good question in that you don't want it to reach a place where you have to advise your client, being a director of a company, to appoint legal counsel. You want, the best case scenario would be, it is okay for a company to be insolvent. The issue comes in with the actions that a court would scrutinize that would lead to personal liabilities on the directors. So that it would be more of, we advise our clients before it gets there to properly ensure that the actions they're taking as the brain of the company are not actions that would be deemed fraudulent or wrongful trading, or even wrongful trading. But even if they have the intention to defraud, which would be fraudulent trading or preferential payments and assignments, to not do that. So that I think it's more about corporate governance more than insolvency.
Thank you for that response. I think the person who asked the question maybe was wondering, whereby if you're a director in a company and maybe out of shareholder pressure or something, and you have to make a decision, and I am the company's lawyer, and so maybe would my counsel guide you accordingly? Should you rely on my guidance, or would you require another counsel maybe to guide you? But thank you, Anthony, for that response. I will welcome Wamuye to respond briefly to the question
Thank you, Fatma. The question is it good practice to appoint an interim liquidator who can't fully wind up a company but decimating the assets of the company through his fees to the detriment of the entire body of creditors? Well, the short answer is no. The long answer is an interim liquidator, even from the name, they are temporary and provisional in nature, and they are often appointed in instances where there's a liquidation petition. So during that interim period before the liquidation petition is determined, and since there are a lot of interest of various stakeholders that have to be taken into account, then the interim liquidator is just coming in to preserve the assets of the company and just maintain status quo and ensure that assets are not being dissipated, and to ensure that all interests of the stakeholders are being protected before the liquidation petition is determined. Of course, it's a very let me say court-supervised process, and therefore, in as much as the interim liquidator is not in the traditional sense an officer of the court, then they owe a duty to report to the court and even to the stakeholders as a whole, just to ensure that the assets are not being dissipated. So in such an instance, of course, you'd be in a position to go back to the court and apply and tell the court that this person is dissipating the assets. Then we need some sort of protection in such a case, and then the court would be able to issue appropriate orders. Fees are also managed by the court. In as much as they're entitled to fees, then it does not mean that they're entitled to fees that are perhaps exaggerated to the entire detriment of other people. I hope that answers the question.
Yes, and just Wamuya, before you finish, there's just an additional question. Can an interim liquidator continue the company business operation, or is his role limited to preservation of assets pending determination of the petition? So I think Victor is asking, if you're an interim director, do you keep the business operation running, or does it stop and you're just preserving the assets and the company until the petition now is determined?
So I'm sure in the course of preserving these assets, obviously there's, for instance, if you're running a business, if at all, then that it means that you're closing down the business. That's basically leading the company into ruin even before the liquidation petition is determined. And of course, we also have to take into account that a liquidation petition having been filed does not necessarily mean that the ultimate decision is to liquidate the company. So yes, the interim liquidator would still be managing business until the matter is determined in court.
Thank you so much. I'd like to direct this question to Noella. So someone had asked, in the context of Kenya, where many insurance companies have collapsed, is the winding up and liquidation the same as a normal company? Maybe I could just share, in Tanzania, we were actually involved and appointed as a liquidator, liquidating an insurance company. So it was the first time that an insurance company was undergoing liquidation in the country. And the law at that time had allowed that if you only have, you're doing general insurance, you do not have life, then as a company, you can liquidate without seeking approval from the regulator. And so I remember when the company resolved to go into liquidation, the regulator became very, I would say, concerned, and it brought a lot of challenges. We almost went to court because they were saying you should not liquidate until the regulator gives you the approval, but the law was not written that way. And so they did allow us to liquidate, to go into liquidation, but it was very difficult. So Noella, Karibu, would like to hear in the context of Kenya and how insurance companies wound up.
So first of all, I will give a disclaimer. I'm not an expert in insurance law, so I will not go into details as to how that process happens. But I think the position is banks and insurance companies are liquidated if they become insolvent or go through a receivership process that is governed by the statute that regulates them. So there's an insurance act that governs the insurance companies in Kenya, and they're regulated by the IRA, the Insurance Regulatory Authority. And my understanding is that any receivership insolvency issues would then be confined to the procedure set out under that act. With regard to banks, they would be regulated a receivership process. They wouldn't have the terms insolvency, given the sensitivity of that particular industry, would also be governed by the CBK Act, that's the Central Bank Act, as well as Prudential Guidelines, as well as the Kenya Deposit Insurance Act, Kenya. So the short answer, without providing details and process and procedure, is that they are carved out, I think, from the Insolvency Act and the normal insolvency processes.
Thank you so much, Noella. And maybe the last question, I'd like to direct this to Isaac. I know he has already responded in the chat, but someone had asked, is there any step toward having a community law on insolvency? So Isaac, being our chairperson of the Insolvency Committee of the East Africa Law Society, I think you're better placed to speak to this. And maybe you can answer my initial question on what should we do as East Africa region is adopting the UNISRITO model law on cross-border insolvency. Will it help us as East Africa in cross-border insolvency? Isaac, karibu.
Thank you, moderator, for giving me this other opportunity. I think to respond to the doctor who posed the question, it's very important that the East Africa really has the adopts a comprehensive and harmonious insolvency law. This will facilitate and boost, as I said in the chat, it will facilitate trade, but more particularly the lenders. The lenders will be much more comfortable to lend other borrowers from other countries within the community with the full knowledge on the process and the cost that it and the certainty of recovery. Maybe in decisions from other jurisdictions. So I think one way the starting point is to adopt the Armstrong model on cross-border insolvency, but tailor it to our local situation, because the Armstrong model on the cross-border insolvency basically it's about facilitating, cross-border administrators, cooperation of courts, but we would want this cooperation to be stated in the law, and that crosses all the East African states. Our countries depend on taxes that traders pay, and I think it is in their interests to really support this idea of having a cross-border and a harmonious insolvency law, particularly affecting that regulates cross-border insolvency. I think that's what I can say to that. But it is us lawyers, as you said, particularly I think the East Africa Law Society has had what the members said, and I think we can champion it through the East Africa Law Society. Thank you. You're muted, Fatima.
Oh. Thank you, Chair, for that response. I just think there was a comment in the chat that someone said we should consider Sudan next time. So I think the East African Law Society has taken note of that. And I think this brings us to the end of our webinar today. And I'd like to take this opportunity to first extend my deepest gratitude to our exceptional panelists for sharing their experience and their insight with regard to cross-border insolvency in the East African region. I think as East Africa keeps integrating and we keep having regional connection, we're going to see a lot of cross-border insolvency matters arising. And as we have throughout this discussion discussed, we as lawyers, people who are probably advising this company, we have the obligation to ensure that we properly advise and guide our client throughout this process. I think normally most of the time companies end up going into when they're facing they detect early. They do not detect early the corporate distress signs. And so normally what results into is that by the time it is noted that there is financial distress or challenges, the company now has to go into liquidation. But also I think I think the culture of also acknowledging that you're facing financial distress is very difficult, maybe in our communities, because it's hard to tell people, maybe to disclose that you're facing financial distress. And normally people fear that if they do, maybe the creditors will immediately come and they will not be able to either go into some sort of coordination or arrangement which can maybe avail them to be able to turn around and go into concern or go into restructuring. However, most of the time, it is also lawyers who are advising the creditors to take stringent action against companies who are facing financial distress. So it is also upon us to ensure that if you're advising the creditor, that you can be lenient and try to engage with the company that is going through financial distress or insolvency, while protecting the interest of your client. And so this marks the end of our webinar today, and I'd like to invite Gabriel to do the closing remark and close the webinar. Thank you so much. And I also thank the participants who have been with us from the beginning until now of this session. We have all learned a lot, and sure, we gained a lot. Gabriel, asante na karibu sana.
Asante sana dada Fatma for that very exceptional session. Special thanks to you, our esteemed panelists, Senior Counsel Chacha Odera. Thank you for giving us time even after your very busy court schedule. Tunashukuru sana. Thank you for making time. To you, Madam Noella, thank you for stepping in just when we needed you. You came rushing like a knight in shining armor. So asante sana. To you, Mr. Anthony Maina, thank you so much for sharing your exceptional views. To you, Madam Wamuyu, thank you so much. Susan, thank you so much. Our very able chair, under whose leadership we all sit, Mr. Isaac Bizumoriemi, thank you so much for your guidance and leadership in structuring this session. It's been quite captivating for us all, and the views that have been expressed by the attendees with regards to having a law have been taken notice of, and in the coming days we'll liaise as a committee to try and actualize some of the matters that have been discussed in this afternoon's webinar session. Our dear participants, of course, thank you for making time and for attending this session. And of course, I cannot end without thanking you, Fatma, for structuring this session. You've kept us on our toes, you've kept us awake, and you've kept it lively and conversational. So thank you so much for your leadership in the committee, but also during this session. We look forward to carrying on this conversation and even scaling further the discussion points that we've had here to have, an impact across the region. And with that said, to our audience that has been following us on YouTube, Pole Sana will forward your questions to the panelists who are not able to get them on time, but we'll forward them and then email you some of those responses. Recording of this session is going to be shared with you on your different email addresses, along with the presentations, if you do require them. You can also catch this recording by visiting our YouTube channel at East Africa Law Society, or you can write to us at info@ELAW Society for us to share this link in the event that you miss out on it. So from us to you, we wish you a very lovely afternoon. You've been a very fun audience. Until we meet again, goodbye and stay safe. Bye. Can now exit at leisure.